Broughton and Grant.
May it please the court, my lady, I appear on behalf of the respondent, with Ms. Jackson, Ms. Adamson, Ms. Malope.
Thank you very much. Yes, Mr. Mill.
May it please the court, my lady, I've drafted heads of argument. I beg leave to hand those up, my lady. May it please the court. Lady, this is an application for leave to appeal in terms of section 316B1 of the Criminal Procedure Act. It's against the sentence imposed by this honourable court on the 6th of July. May I at the outset, my lady, refer to the case of S versus Mabena and others. I will not refer to the references, it's all in the heads, my lady, where the Supreme Court of Appeal enunciated in broad terms on the correct approach to an application for leave. And I quote, "It is the right of every litigant against whom an appealable order has been made to seek leave to appeal against the order." We then emphasize, my lady, such an application should not be approached as if it's an impertinent challenge to the judge concerned to justify his or her decision. A court from which leave to appeal is sought is called upon merely to reflect dispassionately upon its decision after hearing argument and decide whether there's a reasonable prospect that the higher court may disagree. May I also refer, my lady, to S versus Smith in the next paragraph. Same court, the Supreme Court of Appeal. What the test of reasonable prospect of success postulates is a dispassionate decision based on the facts and the law that a court of appeal could reasonably arrive at a conclusion different to that of the trial court. The court added, in order to succeed, therefore, the applicant must convince this court on proper grounds that it has prospects of success on appeal and that those prospects are not remote but have a realistic chance of succeeding. Thus, my lady, in paragraph 4, we respectfully emphasize that the present application for leave to appeal ought not to be construed in relation to any aspect as an insult to this honourable court judgment on sentence. Contrary, my lady, to what has been submitted by a respondent in his written opposition to the state's application. It's respectfully submitted that the application for leave to appeal ought merely, my lady, to be viewed as a valid application where the state respectfully seeks leave to appeal against an appealable order, a sentence. My lady, I will deal with the essence of our argument, and then we've highlighted certain misdirections that we think we want to highlight today. As far as the essence of our argument is concerned, my lady, we respectfully argue that the sentence of 6 years imprisonment on the murder conviction is so shockingly and inappropriately lenient and is founded on a number of material misdirections. My lady, in paragraph 2.5, we respectfully submit that although we have enumerated several misdirections in our application, we will, for purpose of the argument today, highlight only a few. Then paragraph 2.2, we respectfully submit that there are reasonable prospects that a court of appeal may arrive at a different conclusion on sentence, and, my lady, find that the sentence passed is startlingly or strikingly disparate from the sentence which the court of appeal may consider appropriate for the crime, the offender, the needs of society, and the interests of the victim or the victim's family. Lady, we will come back to paragraph 2.3 on quite a few occasions. It's respectfully submitted, my lady, that the sentence imposed reflects an overemphasis of the personal circumstances of the offender and is not in proportion to the objective gravity of the crime, the interest of society, and the interest of the victim and the victim's family. It's accordingly respectfully submitted that there are reasonable prospects that a court of appeal may interfere with and increase the sentence on appeal. My lady, in paragraph 2.6, we argue that the test is, if it can be shown that the material misdirection in the imposing of sentence may reasonably be found to exist by a court of appeal, this court should grant leave. My lady, in paragraph 2.7, we argue, it's respectfully submitted that this fact is so given that it's a tried principle that the sentence may be vitiated by material misdirection. We refer to the Director of Public Prosecutions, KwaZulu-Natal versus P, where the SCA held, milady, and that's important. The test for interference by an appeal court is whether the sentence imposed by the trial court is vitiated by irregularity 1, or misdirection 2, or 3, milady, is disturbingly inappropriate. We also, milady, in the same paragraph referred to S versus Bogarts, where the Constitutional Court confirms that while sentencing falls within the discretion of the trial court, an appellate court may interfere with a sentence where there's been an irregularity, milady, that results in a failure of justice. 2, the court below misdirected itself to such an extent that a decision on sentence is vitiated. Or 3, milady, a sentence is so disproportionate or shocking that no reasonable court could have imposed it. Milady, this principle is so well established, it goes as far back, and we refer to in paragraph 2.8 as the well-known decision of S versus Pillay, that if there's a misdirection, Court of Appeal may interfere. Milady, may I then refer to paragraph 2.9, and milady, with the utmost respect, I cannot emphasize this enough. We respectfully submit that it's not incumbent on the applicant to convince this court that this court in fact misdirected itself on sentence, but, milady, merely that another court may reasonably find that this court materially misdirected itself, which would warrant the Court of Appeal to interfere, milady. Milady, whilst it's easy with respect, and I've done so on many occasions, my lady, to argue in opposing an application for leave to appeal against sentence that the sentence is comprehensive and balanced. And my lady, whilst at the time of sentencing, this court have regarded the sentence as appropriate. And my lady, whilst the court may still regard the sentence as appropriate today, an objective reappraisal of the sentence by a Court of Appeal may reasonably lead to the conclusion that material misdirections were occasioned by this court, which vitiate the sentence, and indeed, my lady, that the sentence imposed is shockingly inappropriate. These 2 paragraphs, my lady, I say with the utmost respect, is very important. That we don't have to convince the court, we just have to show that the Court of Appeal may reasonably find that this court misdirected itself or that the sentence is shockingly inappropriate. And that would be our approach, arguing further as far as this application is concerned. Lady, in 2.11, we respectfully submit that we refer to a number of legal principles in our application. We argue that a number of legal principles have crystallized over time, which a court should consider in sentencing an accused. We refer to extensive case law in our argument before sentence, and further in our notice of appeal, my lady, which articulates this well-settled principles on sentence. We have referred to the principles, my lady, enunciated in these cases, which are pertinent to the question of proper exercising of the court's sentencing discretion. These principles, my lady, with the utmost respect, are binding on this court and ought to shape the exercising of the sentence discretion. My lady, a failure to adhere to such principles in the passing of sentence may constitute a misdirection and consequently, my lady, warrant interference with the sentence on appeal. We do not, my lady, with respect, refer to inapposite extracts taken out of context. We argue, my lady, that respondent's written argument, therefore, on this particular aspect is interesting. The reference, my lady, is to principles in the case law, and we say with the utmost respect that this court is bound by the principles enunciated in these cases. My lady, in paragraph 2.2 we say, after all, an essential inquiry with respect in an appeal against sentence is whether the sentencing court, in imposing it, exercised its discretion properly and judicially. The exercise of a judicial discretion on sentence requires the court to give a balanced evaluation of the gravity of the offence, the interests of the offender, the interests of society, and the requirements of good administration of justice. My lady, we say that a sentencing discretion is judicially exercised when the sentence passed, my lady, is free of any irregularity or misdirection and is proportionate to the crime, the criminal, the interests of society, and the interests of the victim, and, my lady, which does not induce a sense of shock. My lady, as indicated earlier, we refer to 6 misdirections that we respectfully would argue that was occasioned by the court in sentence. Firstly, my lady, paragraph 3.1. Whereas the court found that murder is always a very serious crime, and that the fact that the accused thought that the deceased was an intruder does not make the crime less serious. My lady, that can be found at page 4164 and 4165 of the judgment. At 4164, at line 20, this court found murder is always a very serious crime. The fact that the accused thought that it was intruder does not make it less serious. That it was intruder does not make it less serious. That's at 4164. At 4165, at lines 18, notwithstanding the above circumstances, it's worth repeating that the murder is a serious offence. In the present case, a deadly weapon in the form of a firearm was used and resulted were devastating. The fact that the murder took place under circumstances described above does not in any way make the offence any less serious. My lady, but then, and we say it with the utmost respect, at 4172, the court misdirected itself in holding that the respondents believe that the intruder had entered the house was a mitigating factor, whereas the court indicating that it does not make the crime any less serious. Especially, my lady, when regard is had to the objective gravity of the crime and the fact that this court and the SCA rejected respondent's version that he acted in putative private defence. My lady, may I pause to refer the court to paragraph 4172 of the judgment of this court.
We'll keep you abreast of the proceedings there at the court.
The accused approached the bathroom in the belief that the intruder had entered the house. That's number one. There's no indication that there was a threat or a perceived threat in the court's judgment. Secondly, it is sufficient. The accused immediately took steps to try and save the deceased's life. Number three, he was distraught and kept on asking God to save the deceased's life and promising to serve him in return. Number four, my lady, he reiterated that the accused showed, that was my argument. The court will then also found remorse by the accused. My lady, we'll get back to this, but whilst I'm pausing, the mere fact, my lady, and if regard is had to page 4172, the accused thought there was an intruder and fired. Not that there was any threat to him, not in terms of judgment and not in terms of what was found in the SCA. My lady, may I then refer to paragraph 3.2? We say that the court misdirected itself in under-emphasizing the trite principle enunciated in Malchus. And, my lady, all the judgment that followed on Malchus, Rosli, Mchichi, Nkunkuma, and Brown, those are the major decisions, my lady. That when sentencing in terms of the minimum sentence legislation, it was no longer to be business as usual, and indeed, the emphasis was to be shifted to the objective gravity of this type of crime and the public's needs for effective sanction against it. But lady, may I have just been reminded where we refer to paragraph 2.4 and paragraph 2.2.1 and 2. That's a cross-reference, my lady, to our application. We will not read our application, but all the paragraphs in our heads, my lady, those are cross-reference to our application. 3.3, and we say that secondly, my lady, the second argument as far as misdirection concerned. This court, my lady, with utmost respect, misdirected itself in finding that the aggravating factors in CASU are outweighed by the mitigating factors. We deal with the aggravating factors and mitigating factors identified by this court in our application. We respectfully submit, my lady, that the court failed to take into account three major factors. These three major factors, my lady, by not taking them into account, underemphasizing their value, amounts to a misdirection and will have a material impact on sentence. First, my lady, it was in the bedroom that the respondent had formed the intention to shoot, and when he realized that there was somebody behind the toilet door, he fired 4 shots. Now, that particular aspect is a material aggravating factor. That not only when the accused arrived in the bathroom did he form the intention to shoot, he formed that intention in the bedroom, walking to the bathroom. When he realized there was somebody, he fired. That must be an aggravating factor, and that factor has not been taken into account with utmost respect. There was no finding that he was threatened, or that that he could have perceived that there was a threat. My lady, we say in point number 2, the Supreme Court of Appeal, as well as this court, rejected the defense that the respondent acted in private defense or even putative private defense. Thus, my lady, and that is perhaps the issue that should be stressed, there existed no justification for the respondent's actions. And perhaps, my lady, the most important factor that the court failed to take into account is that the respondent fired 4 shots through the door, and he never offered an acceptable explanation for having done so. We say with utmost respect, my lady, although the court gave effect to the fact that the judgment and the conviction was changed from culpable homicide to murder by the SCA, we argue with respect that the court failed to take into account the inferences and findings made by the SCA. Those the court should take into account. My lady, may I refer the court there to the finding of the SCA, where at paragraph 36, my lady, the SCA explained as a matter of law that it could draw different factual inferences from the primary facts found proved by this trial court. So the inferences drawn from the primary facts, my lady, those are binding on this court. And we say without disrespect, it did not get the necessary attention and emphasis in the sentence, in the judgment on sentence. We then, my lady, we say at paragraph 3.4, it's respectfully submitted that had the court properly weighed these aggravating factors, together with the objective gravity of the crime of murder, the interest of society and the interest of the victim and the victim's family, the court could not reasonably and judicially reach the conclusion that the mitigating factors outweigh the aggravating factors. But it's, with respect, even more so, when with respect, the triad principle is borne in mind that, as enunciated in S. v. Vilakazi, in cases of serious crime, the personal circumstances of the offender by themselves will necessarily recede into the background. And to elevate the personal circumstances of the accused above that of society in general, and the victim or the victim's family in particular, would not serve the well-established aims of sentencing, including deterrence and retribution. We refer to The Court of Appeal matter, Hewitt versus the State, it's not been reported yet, my lady. May I hand up a copy of this particular judgment? Where it was found that scrupulous care must be taken not to overemphasize the accused's personal circumstances without balancing those considerations properly against the very serious nature of the crimes committed, the aggravating circumstances, and the consequences for the victims and the interests of society. And we add here, and the victim's family, my lady. Thirdly, my lady, we argue that the court misdirected itself in finding that the accused is a good candidate for rehabilitation. And then what's important is the following, my lady, and that the other purposes of punishment, although important, ought not to play a dominant role in the sentencing process. That was the finding of this court. Whereas, my lady, the trite principle is serious crimes will usually require that retribution and deterrence should come to the fore, and that the rehabilitation of the offender will consequently play a relatively smaller role. We say with the utmost respect, my lady, that, and it's an argument in this application, that that's a misdirection in terms of the well-established principles on sentencing, my lady. We say, my lady, with the utmost respect, as we said in paragraph 2.3, that this particular aspect was elevated to an overarching factor, which is against the principles. We say in paragraph 3.8, my lady, it's respectfully submitted that the court could not reasonably and judicially find that the respondent is ripe for rehabilitation when it's considered that seeds of rehabilitation can, in a manner of speaking, germinate only if the convicted person himself has first and foremost expressed contrition for his criminal wrongdoing, thereby accepting the gravity of the criminal act of which he and she has been convicted. My lady, the defense called Professor Dr. Scholes to try and explain that the accused accepted his conviction and change of conviction. But, my lady, we say that the court correctly rejected the version of the accused about the suicide in prison. But we argue, my lady, that although the court rejected that version, perhaps the court did not give enough effect to the inference that this was just another lying version by the accused that we got used to. And probably, my lady, an attempted manipulation of the process by trying to portray what he experienced in prison, my lady. My lady, he never testified. The fact that he accepts the gravity of the criminal act of which he has been convicted has not been tested, my lady. We respectfully argue, my lady, that the court misdirected itself in finding that the respondent is genuinely remorseful, where the Supreme Court of Appeal made it patently and repeatedly clear that one really does not know what his explanation is for having fired the fatal shot. The SCA said that, my lady. This court, with the utmost respect, should give effect to what the finding of the SCA. But, my lady, it goes one step further. During the cross-examination of Professor Scholes, it was put to him that this accused elected to give a version to the world, but he never testified in this court. My lady, may I then say, where the court correctly rejected Professor Scholes' evidence that the accused's condition is not such that he should be hospitalized, by inference, my lady, the court also rejected, or at least should have rejected, the version that his condition is so severe that he's not able to testify. The court made credibility findings about Scholes. The court rejected his version on the suicide, although that comes from the accused. As far as the condition is concerned that he should be hospitalized, that was also rejected. My lady, and therefore by inference, the court should have rejected the fact that the accused was in no condition to testify. My lady, in paragraph 3.10, it's respectfully submitted, my lady, that the court misdirected itself in failing to take into consideration that there's a distinction between, on the one hand, responding having exhibited some regret for his actions after the killing and in seeking forgiveness from the deceased family for the mistake of having killed his girlfriend, and genuine remorse. There's a distinct difference between the two. On the other hand, which the respondent does not have, in that he still has not given a satisfactory reason for having fired the fatal shot. That is to say, he has still not sufficiently indicated what motivated him to commit the murder. We say with utmost respect, my lady, the court failed with respect to take into account or give adequate consideration to the well-established fact that there's a chasm between regret and remorse. Many accused persons might well regret their conduct, but that does not without more translate to genuine remorse. Lady, I can do no better than to refer the court to the very well-known decision of Machichi as far as remorse is concerned. May I just read one specific quote from Machichi? Lady, I'm reading a summary of the Machichi judgment that can be found in S versus Nkunkuma, my lady. In S versus Nkunkuma, there's reference to Machichi at paragraph 14. And it says, in order for remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. Lady, and what we're saying, and we'll get back to this, with the judgment of the SCA known to the accused, where the SCA said on more than one occasion that the reason for the firing of the shots are not known, we really just don't know. Well knowing that that exists, that the SCA said, we don't know why he fired the shots. The accused elected not to testify. His remorse and or prospects of rehabilitation could not be tested. But that we continue, my lady, paragraph 3.11, we say that the court, with the utmost respect, misdirected itself in underemphasizing the principles expressed by Boshielo J. Hay, in the Director of Public Prosecutions, North Gauteng versus Tabete. Namely, my lady, it's tried that one of the essential ingredients of a balanced sentence is that it must reflect the seriousness of the offence and the natural indignation and outrage of the public. Fourthly, my lady, the court, with respect, misdirected itself in underemphasizing the tried principle that when sentencing in terms of the minimum sentence legislation, a court is not given a clean slate on which to inscribe whatever sentence it thinks fit or appropriate. But the starting point in a matter such as this, my lady, is the prescribed minimum sentence ordained by the legislature. My lady, we then say, with respect, that the court failed to appreciate that the starting point in the present matter was a sentence of 15 years imprisonment. To have reduced a sentence from 15 years to 6 years for murder, notwithstanding the mitigating factors or personal circumstances of the respondent, it induces a sense of shock. A fortiori where the court did not stipulate what the substantial and compelling circumstances were, which seemingly the court regarded as justifying the imposition of a lesser sentence. Lady, by inference, page 4172 is an indication of the substantial and compelling factors that this court took into account. Those are four, my lady. With the utmost respect, we say that taking into account all the mitigating factors in the judgment, that it is shocking to think that a sentence of 6 years from the starting point of 15 years is appropriate. We say that the court, with utmost respect, viewed sentence as starting from a clean slate, where the court should not have. The court should have started at 15 years. It goes even further, my lady. My lady, this specific principle that the starting point in a matter such as this is a prescribed minimum sentence ordained by the legislature. That specific point, my lady, has been followed by Malchus, Machichi, Nkukuma, and Brown. It's a well-known tried principle that should be followed, my lady. Failure to do, my lady, we say with the utmost respect, amounts to misdirection, or that the SCA may view this reasonably as a misdirection. My lady, the court, with respect, misdirection, we had 3.13, misdirected itself in underemphasizing the tried principle that when sentencing in terms of the minimum sentence legislation, a court must assess whether, in all the circumstances, the sentence is proportionate to the crime committed and whether the sentence is a just one. While each case must be assessed on its own merits, the court found that. We respectfully submit that the court nevertheless misdirected itself in underemphasizing the tried principle that when imposing sentence in terms of minimum sentence legislation, a severe, standardized, and consistent response from the courts is required, paying due regard to the sentence that ought ordinarily to be imposed for the commission of the listed crimes. My lady, we referred in 3.15 to Malchus, where in Malchus, even if the court find that there are compelling and substantial circumstances, account must be taken of the fact that the crime of that particular kind has been singled out for severe punishment, and that the sentence to be imposed in lieu of the prescribed sentence should be assessed paying due regard to the benchmark which the legislature has provided. 15 years, my lady. That's the benchmark. There's no clean slate, my lady. It starts there. Compelling and substantial circumstances should be and could be taken into account, but with reference, my lady, of the starting point and not of a clean slate. We say, my lady, in paragraph 3.16, the court with respect materially misdirected itself in underemphasizing the tried principle that even where the substantial and compelling circumstances are found to exist which justify the imposition of a lesser sentence than the minimum prescribed sentence, the sentences prescribed create a legislative standard that weighs upon the exercise of the sentencing court's discretion. This entails sentences for the scheduled crimes that are consistently heavier than before. That is Abrams' matter, my lady, and a factor that's been elevated to a principle as far as sentence concerned. A principle in considering sentence where minimum legislation is involved, my lady, and the court should follow those principles. My lady, at 3.17, we say the court materially misdirected itself with respect, finding that long-term imprisonment would not serve the justice in this case. Also having regard to the following factors, my lady. Having regard to the factors which was found by the Supreme Court of Appeal, which are based on the court's finding of fact, and that can only be this, my lady, that the respondent fired 4 shots at the toilet door because he thought there was an intruder in the toilet. May I pause, my lady, by saying, to view that fact as a substantial and mitigating factor would indicate, my lady, that taking into account the judgment of the court, and I say with the utmost respect, that the life of an intruder behind the closed door where he cannot escape is not worth much. My lady, even if he thought this was an intruder, there was just no threat. He walked to the bathroom and fired 4 shots. That is the finding, my lady. The finding is, he decided in the bedroom to shoot at whoever, if there was somebody in the bathroom. Whoever. That was the finding, my lady. Whoever was in the bathroom. When he realized there was, he fired. There's nothing else, my lady. The vulnerability we'll get to. But that is the fact of his intention. Was formed to shoot whoever. And we cannot, with my lady, with the utmost respect, argue that even if he thought there was an intruder behind a closed door in a small cubicle, that's a mitigating factor because the life of an intruder is not that important. That can never be the court's finding, with the utmost respect, my lady, and amounts to a misdirection. We say, my lady, there was no indication of a real or imminent or immediate threat at all, because this version was rejected. The Court of Appeal said, we just don't know. We respectfully submit that our courts are enjoined to severely punish a accused person who shoot and kill without reason. Respondent exhibited some regret when it turned out to be the deceased, but has as yet not given a credible explanation of why he fired the shots. Lady, in a matter by the Deputy Judge President of this division, S. versus Martin, the court put it very succinctly, my lady. Where the court said, S. versus Martin, the decision of this division at 176J, to determine sentence, particularly for a more serious crime, there is not a more important question than. This was 1996, my lady. Why did you do it? It's hardly excusable to ask a case how many children he has and to admit the crucial why did you do it. With no known answer to that question, the accused is at risk, appearing to have acted without reason and to deserve the harshness which accompanies wanton criminality, which is executed without anything which reduces moral reprehensibility. Now, it is a judgment by one judge in this court in a trial, but it sets it out what we try and portray, my lady, and what the SCA said, my lady, what the, by saying we don't know. Now, by don't know, the only person that can tell us why and give us a credible explanation is the accused. At the moment, my lady, the finding is he formed his intention, he walked to the bathroom, he saw there was somebody, realized there was somebody, he fired the shots. My lady, fifthly, and perhaps, my lady, the most material misdirection is in not where the court failed to grade the degree of dolus eventualis. We respectfully submit, my lady, that this court misinterpreted Supreme Court's findings as to the degree of foreseeability. We say, my lady, that, and respectfully argue, that the court was bound by the inferences drawn by the Supreme Court of Appeal based on the factual findings of this court. The court is bound by it, my lady. We say that the court materially misdirected itself in finding that there is no suggestion in the judgment of the Supreme Court of Appeal that the dolus eventualis or respondent bordered on dolus directus, whereas the Supreme Court of Appeal held, and we'll then refer to that. My lady, may I argue by saying that appeal court, the SCA never said it borders on it, but the SCA indicated what the degree of foreseeability is. My lady, in the first sentence, the court took into account a degree of negligence. My lady, it's exactly the same, with the utmost respect, as far as dolus eventualis is concerned. Dolus eventualis could be foreseeability as a remote possibility. That's on the one end of the scale. And on the other end of the scale, my lady, we say, as was found by the SCA, as a matter of common sense, at the time of the fatal shots were fired, the possibility of the death of the person behind the door was clearly an obvious result. Remote possibility to obvious result. My lady, they cannot, I say this with the utmost respect, but there cannot be a degree past obvious. Because if there's a degree past obvious, that must be dolus directus. The next step after obvious, my lady, must be dolus directus, which means, my lady, that this is very close to dolus directus. We've never argued those directives, and we don't do it now. But what we argue is that if the result is obvious, then it's very close to it. But it goes further, my lady. And in firing not one but 4 shots, it became even more likely. Likely and obvious, my lady, is a degree within those directives. Those eventualis, I apologize. We've highlighted the last sentence. In the light of the nature of the firearm and the ammunition used and the extremely limited space into which a shot was fired, the difference is understandable. A reference to when counsel argued. Right? So our argument is that it was a misdirection by the court to make a finding that there was no suggestion in the judgment of the Supreme Court of Appeal that Dolus eventualis of the respondent ordered on those directives. We say it's clear that the only inference is that that is what's meant by the portion that we quoted there. We submit with respect that the court's material misdirection in not grading the respondent's Dolus eventualis as bordering on Dolus directives is also borne out by the following facts accepted by the Supreme Court of Appeal. And we quote, my lady, the deceased must have been standing behind the door when she was first shot and then collapsed behind the toilet bowl. Although the precise dimensions of the toilet cubicle do not appear from the record, it is clear from the photograph that it's extremely small. And it's also apparent that all the shots fired through the door would almost inevitably have struck a person behind it. There had effectively been nowhere for the deceased to hide. My lady, if you fire through a door, knowing that there's nowhere to hide, and even if that's an objective fact, that is very close to those directives. My lady, we also refer to where the SCA discussed Captain Mangena's evidence. My lady, we argue that Captain Mangena's evidence was taken into account at the reconstruction of the scene, was taken into account by the SCA. But it was given no weight, my lady, with the utmost respect, by this court in the evaluation of sentence. My lady, we also, may I pause? We've referred to the family, we've referred to the accused as a fallen hero in the judgment. But, my lady, with the utmost respect, this court did not give effect to the horrendous death that this deceased suffered. My lady, that is something that should be taken into account with sentence. In a small cubicle, while one after those shot is fired through a door, it's just a horrendous way of dying. And my lady, not the misperception or the fight is the issue that bothered Mr. Steenkamp. This issue, what happened to her? What did she experience when the shots were? That is what bothers Mr. Steenkamp in his evidence. With utmost respect, my lady, it was underemphasized in the judgment of this court. My lady, at 320.2, Captain Mangena testified that the black talon ammunition the accused had used was specifically designed for the purpose of self-defense. It would penetrate a wooden door without disintegrating, but would mushroom on striking a soft, moist target such as human flesh, causing devastating wounds to any person who might be hit. The veracity of this is borne out by the photographs depicting the injuries the deceased sustained, correctly described by the trial court as being horrendous. My lady, that fact that black talon ammunition was used is an aggravating factor that should be laid, that should be blamed on the accused. Well knowing what kind of ammunition he used, he still used it. We say with utmost respect that that did not get the attention of this court in sentence than it should have. The scene and the ammunition used and what happened to the deceased while she was in that toilet cubicle, those are all very aggravating factors, my lady. And if that is weighed against an accused who apologized after the event and wanted to, was regretful on the night that it happened, pray to God, that would then fade into insignificance. Because the seriousness of a crime should come to the fore in crimes like this. 3.20.3, my lady, I'm not reading the whole paragraph, the last sentence. He paused at the entrance to the bathroom. When he became aware that there was a person in the toilet, he fired 4 shots through the door, and he never offered an acceptable explanation for having done so. My lady, we are mindful of the fact that we don't have to convince this court that this court erred. And that's not what we're trying to do, my lady. But what we're saying is that was known to the accused when this court resentenced, that particular paragraph saying, and he never offered an acceptable explanation for having done so. Well, knowing that that's a finding that this court will take into account, he elected not to testify. Elected to call Professor Scholes, and Professor Scholes wasn't a good witness. We say, my lady, that in paragraph 3.21, we respectfully argue that the proper grading of a respondent's culpability would lead to a much heavier sentence, and thus there are reasonable prospects that on this basis alone, a court of appeal will interfere with the sentence. Lady, when we started with the misdirections, and at paragraph 3.1, where we said that murder is always a serious crime, even if the deceased thought that it was an intruder, and that was later used as a mitigating factor. That, my lady, linked with this, and I say it with the utmost respect, failure to grade the notice of inchalis would, my lady, allow a court of appeal to reasonably, after reasonable consideration of all the facts, to interfere with the sentence. As far as the sixth grouping is concerned, my lady, at 3.22, we say that the court erred in regarding the vulnerability of the accused as a mitigating factor. The court did not over-exaggerated that. We respectfully deal with this aspect in our notice of appeal, paragraphs 210.1 to 210.5. I've got the wrong, but the head you have, it's a correct reference. We respectfully argue that both the court and the Supreme Court of Appeal pointed out that despite the respondent's disability and vulnerability, he was able to overcome such and excel in life, particularly in relation to his major athletic achievements worldwide. But, my lady, what's perhaps more important is the next sentence. More importantly, with respect, the court's material misdirected itself in overlooking or underemphasizing the Supreme Court of Appeal's finding, and that's a finding, my lady, that this court was bound by, that the respondent's subjective intention was unaffected by the accused's physical disabilities, the fact that he had not been wearing his prosthesis at the time, that he had thus been particularly vulnerable to any aggression directed at him by an intruder. The Court of Appeal made a finding, my lady, that his subjective intention was unaffected by that. We quote the appeal court again. May we add, my lady, that the court refers to the physical demonstration by the accused in court. But, my lady, the physical demonstration of the accused at the night would have looked something different. It would have been an accused walking down a passage armed with a lethal firearm, ready to shoot. My lady, that's not vulnerable. That is, if somebody's armed with a firearm, a lethal firearm, loaded with ammunition that would devastate, such a person is formidable, not vulnerable. That is the person, not the person that walked in court, my lady. but the person that night that walked down that passage shouted at the intruder. When he saw him, he fired the shots. That is the person that this court should take into account. My lady, I have to switch. We deal with the misperceptions at paragraph 3.2.3. We respectfully argue that this court, with respect, my lady, misdirected itself in regarding the misperception in the public that the argument between the respondent and deceased preceded the killing as a factor that could not be ignored in determining an appropriate sentence. It was never, with respect, our contention on sentence that there was an argument before the murder was committed. We never argued it, and this court should never have taken that into account. The public's misperceptions, my lady, was, with utmost respect, entirely irrelevant to a matter of sentence. As an operative comment, perhaps, my lady, but to be taken into account, a misperception by society about a conviction is not an aspect that should be taken into account. We say, with the utmost respect, it's irrelevant. What was relevant, however, as far as society is concerned, is that society had an interest that the respondent be appropriately sentenced on a very serious crime perpetrated against an innocent, defenseless woman who had nowhere to hide when the shots were fired, particularly when no acceptable reason was proffered by the accused to this court for having fired the fatal shot. Society had an interest, my lady, in a sentence being imposed that adequately reflect its disquiet experience in relation to the nature and gravity of the crime committed, which disquiet, my lady, is expressed in the minimum sentence legislation. It is this public interest that the court had to give sufficient weight to in passing sentence. As this court with respect correctly pointed out before proceeding to focus on an emphasis, at first the court said, the interest of society demand that people who commit serious crimes such as murder must be punished severely. The court said, this court will not be swayed by public misperceptions. But the court then took this into account and said it's an important factor that should be taken into account. And we say with utmost respect, a court of appeal may find that that amounted to a misdirection and that the court of appeal would have a right to interfere with sentence. Conclusion, my lady, we respectfully submit that the reasonable prospect that a court of appeal may find that the misdirections dealt with in our application were occasioned by this court, which misdirections are material and would thus vitiate the sentence imposed. Further respectfully submitted that a reasonable prospect that a court of appeal may find that the sentence passed is shockingly and inappropriately lenient and strikingly disparate from a sentence which a court of appeal may consider appropriate for the crime, the criminal, and its society. We accordingly respectfully submit, my lady, that the test has been satisfied for the granting of leave to appeal against the sentence in this matter and ought thus to be so ordered. My lady, in terms of the Criminal Procedure Act, in the way I read it, the state only has a right to appeal to the SCA and not to a full bench. Section 316B makes that clear, my lady, that we don't have a right to appeal to a full bench, we only have a right to appeal to the SCA. And therefore, my lady, we respectfully submit, it's 316B1 is clear, my lady. Subject to subsection 2, the Attorney General may appeal to the appeal division against sentence imposed upon an accused in a criminal case in the Superior Court. Therefore, my lady, we apply for leave to appeal to approach the SCA. As a court, please.
Thank you very much, Mr. Nat.
As a court, please.
Yes, Mr. Rowe.
Thank you, my lady. My lady, if this judgment was so fraught with material misdirections and so shockingly inappropriate, I would have expected the state on the day of the judgment when it was invited, like the defense was invited, to say, do you have any application for leave to appeal? To there and then bring the application, because it was so patent and so obvious that it was a bad judgment, flawed and fraught with misdirections. Instead, the state waited 15 days, let the respondent sit in jail, subject him to uncertainty, and that's the story of his life in this case. And I find it so difficult to find a proper application of the constitutional approach without fear, favour and prejudice. I understand it without fear and I understand it without favour, but unfortunately I see a lot of prejudice against the accused coming from the state side, and especially in the submissions. And I use one example that's striking, by just suggesting that he showed some regret after realizing it was the accused. That is so wrong. The man was crying, he was praying. Even the state witnesses explained that state of mind, and to come and call it some regret just tells us that it's not a fair appraisal of this matter. But my lady, I've reread the judgment with my colleagues, and I really believe, and I need to say that the judgment made me proud of judiciary. It dealt in context with every aspect. I can't state the same about the state's approach in this matter. That I cannot say that it evokes the same compassion. Their case, the state's case, is presented, and you will see it in the notice, with repetitive grounds. It fragmented the judgment, and there was just a failure to read the judgment in its proper context. They take out little pieces and then quote cases. But those cases, if you look at the facts of those cases, they're wholly inappropriate. It's not the same. It's no use to quote cases and then say to the court, you erred and that should have been the approach. Look at the facts of that case, try and compare it to this case and see if there was really that misdirection. The state tells you that if there's a reasonable, if another court could reasonably come to another decision, you should give leave. That's not correct. That used to be the approach. We referred you in our opposition to Tonkin's case. It must be a reasonable prospect of success. Now let's deal with that, my lady. I was waiting for the state to say, well, although we did not say it in our notice, but we have to concede today that when we tell the court that this sentence of 6 years is shockingly inappropriate and everything that's bad that a judge could do, I would have thought, after reminding them in our opposition, that they would say, well, actually it's not a 6-year sentence only. It's far more. Actually, the court repeatedly said in the sentencing judgment that I take into account the sentence already served, the correctional supervision, the detention thereafter. The state just ignores it. It's just as if it never existed, as if this sentence was just isolated 6 years. It's not. We try to demonstrate in our opposition to say, having regard to the fact, unless a person really behaves badly, that you would set about 60% of your time. That is an effective sentence of 8 years that he received. That's not lenient. Not at all. What is it that the state wants? 10 years as opposed to 8 years? 8 years as opposed to 6 years? What is the practical effect of that? Is that practical effect as such, if there's any justifications for it, that it would warrant that the legal process should be perpetuated and go on, and that the respondent should sit and further subjected to uncertainty? It cannot be My lady, with great respect, I understand judicial scrutiny, but it has its limits. Once you look at the matter and you feel enough's enough, it does not comfort you that the process is fair and reasonable. It does not evoke a feeling that justice must be seen to be done and let's go to another court because this was so wrong. That is not the case before you, my lady. Again, I say it's unfair to fragment your judgment and to take the 6 years in isolation. That's not the sentence. That's the ultimate effect of the sentence combined with the previous sentence. Did the state take into account how it must feel when you sit in jail and you serve your time and you come out and you think you've done what you should have done in accordance with a valid judgment, and then to be sent back to jail? That's hard. But if there was justification for it, and it was, the court properly dealt with it. The court explained the court's approach to the Supreme Court of Appeals judgment, took those factors into account, and increased the sentence. And not increase it only from the previous 2761I, effective 10 months, it increased it from 10 months to 6 years, plus the years served, plus the correctional supervision already served, plus the incarceration, the stringent bail conditions thereafter. That's very different from what the state is submitting today. And I'm still trying to understand, what is it that the state wants? What is it that the state wants that's going to be effective? What is it that the state wants that's going to be justified, that would justify subjecting the accused to a further uncertainty, send him like a ping pong ball between courts? If it's necessary, yes, of course, but I don't see it. I looked at these misdirections, and the state tells you, he says, well, there was no threat. Just to use one example. Well, lady, we live in a real world. If I wake up 3 o'clock in the morning and I believe there's an intruder in my house, it's dark, I don't have legs to walk on, to say in my mind there's no threat, that cannot be. We have to look at the mindset. We're dealing with sentence, and the court correctly took that into account. He says that he went with this murderous intent. He planned to shoot in the bedroom. It's just as if you delete the evidence that he was calling out, get out of the house. Yes, I'm not attacking the merits, they're there. We accepted that. But we can't ignore that. If you want to kill the guy, why do you want to get him out of the house? What about his evidence that he heard this noise that resembled someone coming out? That's just ignored. It's just being ignored by the state. It cannot be. If you really want to come to court and you want to persuade a court or convince a court that there's a reasonable prospect and that there were serious misdirection, at least put the fair and full picture before the court and then analyze it and then compare it. But we don't see it. It's rather, he didn't give a proper explanation. Let's punish him and punish him and punish him. The court has found that correctly so. The court has taken that into account correctly so. And the court then focused not only on the accused, the court fairly dealt with the evidence from Kim Martin of Mr. Steenkamp. The court repeatedly emphasized that this was serious. So where is this misdirection? It is a perceived misdirection, and it's measured against a sentence that is not the sentence. And on the other hand, if you take the sentence which took into account the previous sentence served, there is nothing, there's a vacuum on the state side. What is it that it wants? It doesn't tell you. But to say that 15 years is the starting point. My lady, I think, and I shouldn't say it, but I think it was an insult to say that this court misunderstood and did not take into account the correct principles in approaching minimum sentence. Just read the judgment. It's clear what the court said. The court dealt with the cases, with the Malgas, with the Vilikazi, with the approach to be followed. There's nothing wrong with it. If you look at it in proper context and not fragmented, that's the correct approach. But if you take one little sentence, I can take in every case one little sentence, and then carry on in that sentence out of context. But put it back in context and look at it holistically, and that is what the state has not done. And that is what brings about this unfairness, and when it militates against a feeling that one gets that, where is this going? What is it that the state wants out of this? I don't know, because they don't tell us, but to say 15 years is a starting point. My lady, with great respect, if one scrapes away the veneer of repetitive sentences, of a fragmented approach to the judgment, and you say to yourself, what is it that the state's really saying? Then you realize they try to bring back what was correctly rejected by this court. They try to bring back this theory of dolus directus, and that the Court of Appeal really involved itself in categorizing the dolus eventualis. The Court of Appeal did not do so. Not at all. It gave certain facts, and some facts it left undisturbed. Totally undisturbed. The Supreme Court of Appeal did not say that the accused was not anxious and was not frightened. In fact, it accepted it. Why? Because that was the court's finding, and it's there. The fact that he did not meet the test for purposes of conviction does not mean that you draw a line through it and then say, well, you stand naked now, you have no facts in your favor. That's not true. You then move on to the mitigation, and that's exactly, we say, what this court has done. We point out every time, my lady, in response, and I don't believe it's necessary to repeat, because it's before the court and we filed it in our opposition to the state's application. Every single time that they make a point, we demonstrated to this court that it's fragmented, that it's out of context, and it's simply not correct. My lady, the test remains, and it remains for a good reason, and we deal with that in paragraph 2 and in paragraph 14 of our opposition. In paragraph 2, it makes it clear that it is for this court. This court is primarily possessed of the requisite judicial discretion to impose a sentence. That does not mean an unfettered discretion, but the court did not apply an unfettered discretion. The court applied the rulings made by the Supreme Court of Appeal. And then that misdirection must be in material respects. What do we get? And then the second point, where the court warned in paragraph 14 in Tonkin and say, it must not just be a prospect or a possibility that another court may interfere. There must be a reasonable prospect. I don't find that. What we see, and is the state in its paragraph 3 saying, and I want to read this. The sentence is shockingly and inappropriately lenient and strikingly disparate from the sentence which a court of appeal may consider. What sentence would a court of appeal consider? What sentence would a court of appeal consider when you tell the court of appeal it's not only 6 years? In fact, this is the background to this. What sentence will a court of appeal consider? What is the reasonable prospect of imposing another sentence? Will the court say that this sentence is so devoid of substance, so fraught with misdirections, that I must interfere? What are they really? But to use quotations from cases All those things we find in a judgment. The court in this matter was at pains to explain that it must be a balanced approach. The court said, in fact, I'm not going to repeat everything, but I take into account what was submitted before me. I take into account what was in the heads of argument and in argument. It's unfair to say, well, you did not now verbatim repeat X and therefore you did not consider it. It's not true. My lady, we submit that if you look at this matter and you ask yourself, why is it that absolute emotion of it's enough is there? Then you realize because there's no substance in the case. For instance, the state suggests that the Court of Appeal finding amounted to a conclusion that there was no remorse. The Court of Appeal did not deal with sentence. It simply dealt with questions of law. It did not get there. It did not look at the personal circumstances. It did not dictate to you what factors in your factual finding you should take into account for sentence. And that's exactly what this court did. And that is the reason in our law why we leave the imposition of sentence in the discretion of the court. You feel it. You smell it. You see it. You're there. You understand the emotions. You look at witnesses. You have that first-hand experience. And then with that, looking at all the facts, you come to what you deem a balanced sentence. Would a sentence always be perfect? No, my lady. Would it always be acceptable to everyone in the community? No, my lady. But that's not the test. I'm trying to find this disparity, this shockingly inappropriate sentence. 8 years in effect. 8 years for a man that's vulnerable, that at night made a mistake of his life and that lost everything he had, that fell from the top to the bottom, that came out of jail and had to go back. 8 years, shockingly disappropriate, shockingly lenient. My lady, it can never be. That exposes the approach by the state. And I submit, my lady, that you should really give consideration to dismiss the application, not to perpetuate what is going on this matter. It should be the end. It should sensibly the end of the judicial process. It has been exhausted beyond the point of exhaustion. I say it with great respect. This trial and this process has been exhausted beyond the point of any conceivable exhaustion. And we submit that you should dismiss the application and that you should dismiss it with cost as provided for in the section. Thank you.
Thank you, Mr. Yes, Mr. Nana?
Please, the court, I have 3 points to make in reply. Firstly, my lady, as far as the effect of house arrest is concerned, we in fact, may I hand up an argument in this regard, where S versus N, the SCA clearly indicated that house arrest as a component of correctional supervision is a lighter sentence than direct imprisonment. And therefore, my lady, to say that it's 8 years is just not so. The court correctly, we never criticized the court for taking into account that the accused served 1 year in prison. The court, he did. As far as house arrest is concerned, my lady, we have the argument there, and we say at paragraph 2 of this particular argument, this court was required to sentence the accused afresh. We say, whereas this court could conceivably take into account when sentencing afresh the period of imprisonment already served by the respondent, this did not include house arrest under correctional supervision when imprisonment was the only appropriate sentence to impose on a murder conviction. He would not have done house arrest, my lady, on a conviction of murder. That's the one point. I said there were 3. Second point, my lady. We never ignored evidence, as was argued. The accused version was rejected. Whatever he said was evaluated by this court and by the Court of Appeal, and that was rejected, what he said, my lady. The mere fact that we don't refer to it, it's not that we're ignoring his evidence. His evidence was rejected. It's not part of, it should not be part of the record. My lady, the last point we want to make is that the SCA, my lady, the court would see that we referred to S versus N and S versus Jeffries in our argument. The last paragraph, my lady, of the reported matter DPP Gauteng versus Pistorius reads, the matter is referred back to the trial court to consider an appropriate sentence afresh in the light of the comments in this judgment. The comments in this judgment are those things that we quoted. We say with the utmost respect, if that was underemphasized, that this court, that amounts to a misdirection. My lady, we're saying that it's strikingly inappropriate. If one starts at 15 years, if we start at 15 years, we cannot get to 6, my lady. We can get to 12, but we cannot get to 6. And if that's where the appeal court would see this, my lady, then it is shockingly inappropriate. So that's our, that's a court.
I think both counsel, I'll take a few minutes break. I'll be back. What's the time? Is it 12:15? I'll be back at 11:45.
As a good business.
Quarter to 10.
All right.
Let's do it.
Next door. Let's